My lord. It's RSA 217/2023. I am the respondent in this matter. This pending for a long time. This last date was 2017
What do you
December
want?
2024. And the respondent is very elderly person.
What do you want?
We're listing the matter
In
next
which
week.
column?
29th July.
Which column?
No, this is the order.
Okay, 29 July.
29 July.
Allowed.
My lord, restoration petition of 2025 RSA case was dismissed. I want on 31/7, my lord. For orders.
Okay, allowed.
Then another for 2013 matter for orders.
Allowed.
RSA. There is a question of history. So my prayer it will be on 29.
When you do want?
29.
Okay, allowed.
Please, Lordship, with the consent of the other side, I beg to mention item number 50, Lordship.
50.
50 in the hearing column, Lordship.
Yes.
In this matter, I filed my wakalatnama and appearing for respondent number 1, Lordship. So I require some time to go through the case before.
Heard Mr. K. Jain, learned counsel for the respondent.
Respondent number 1, Lordship.
Respondent number 1, who submits that he has been recently engaged by the respondent number 1 and he needs some time to go through the case. Hence, prays for an adjournment. He submits that he has informed learned counsel for the appellant regarding his prayer for adjournment, who does not have any objection to same. Hence, the prayer is allowed. Let this matter be listed after 2 weeks on a date to be fixed by registry.
Kindly date my
Lordship. I'm for the appeal, Lordship. Date may be fixed, Lordship.
Yes, 5th of November.
Last month, August.
in September first week, Lordship.
Lordship,
Any date.
5th of November.
the injunction matter, Lordship.
After 4 weeks on a date to be fixed by
Okay.
registry.
Much obliged.
May it please your Lordship. Lordship, I would like to mention, in fact, 2 cases not related. Lordship, in one, the execution has started. In the other, the court is going, has passed ex parte order, though the CRP is pending here, Lordship. So on Monday, Lordship.
Okay.
Highly obliged.
May I please, your Lordship, Lordship, I am paying for listing of a civil revision petition, Lordship. This matter pertains to compensation, Lordship, because the railway has
Which
in
state?
the admissions
When do you want?
any day next week, Lordship.
31st.
I'm paying for listing RSA for hearing on 29.
Hearing no listing by.
It was fixed for out of a turn hearing, but on the last date it was left over. It was already in the hearing list, and it was due to my application for early hearing.
Okay, 29.
Lordship, may I pay for listing of a content matter, Lordship? Notice was issued 2 months back and already service is completed now, Lord.
When?
Can it be 28 or 29?
29th.
May I please, your Lordship? Lordship, I pray for listing of a transfer petition, Lordship. It was last listed on 13/6/2025.
When do you want?
Next, any date next week, Lordship.
31st.
Much obliged, Lordship.
May I please, Lordship, I am paying for listing of aforesaid. So Monday, Lordship.
Okay.
Your Lordship, I beg to mention the listing of arbitration petition numbers 31 of 26
When?
on Tuesday, 28th.
Okay.
May I please be, Lordship? I beg to mention 2 items, Lordship. One IA for release of 50% deposit and one MAC appeal, which was condoned in last year, 26 March 25, but is not listed. So IA is in for orders column, Lordship, 29th of July.
Okay.
Thank you.
Lordship, I beg to mention listing of 3 MFS in orders column, my lord, in August 1st week.
7th of August.
Much obliged.
May I please, Lordship? Lordship, kindly adjourn at item number 47 and visit on another convenient date.
47. What is your name?
RM Lamin.
Heard Miss R.M. learned counsel for the applicant who seeks an adjournment. The prayer is allowed. Let this matter be listed after a week on a date to be fixed by registry.
Which I would like to mention one orders from IA for collection of the order on 29th.
Okay.
May I please, Your Lordship? With the other parties concerned, I beg to mention item number 8, Lordship. Lordship, kindly, this matter may be adjourned for today.
Why?
Lordship, there is some personal difficulties.
Heard Miss, what is her name?
See, Saikya, Lordship.
Heard Miss C. Cycle, Learned Counsel. Item number 8.
8.
You have informed the others.
Yes, they have it.
Ms. C. Cycle, Learned Counsel for the appellant who seeks an adjournment on the ground of personal difficulty. Ms. R. D. Majumdar, Learned Counsel for respondent number 2 and 3 does not raise any objection. Hence,
They said about flood.
okay, hence the prayer is allowed. Let this matter be listed after a week on a date to be fixed by registry
Can be on 5th of August, Lordship.
on 5th of August.
Highly obliged.
Wait, please, Your Lordship, I beg to mention item number 2, Lordship. This has been longly listed in the admission column, Lordship. It should have come in the orders column. Lordship, a date may be fixed and it should come in the orders column. Lordship.
Heard
That
Miss,
is admitted.
what is your name?
S. Todi, Lordship.
Heard Miss S. Todi, Learned Counsel for the appellant who submits that this matter has been wrongly listed in admission column. Stop. It ought to have been listed in orders column. Registry to accordingly list this matter in orders column after a week on a date to be fixed by it.
Obliged, Lordship.
May it please your lordship, I beg to mention item number 45 of the daily cause list and 52 of the supplementary cause list. In both the cases, we are the appellant and we have taken the consent. Lordship, kindly adjourn the matter for 2 weeks.
Heard Miss
D. Goswami.
D. Goswami, Learned Counsel for the appellant who seeks an adjournment on the ground of personal difficulty of the conducting counsel for the appellant. She submits that she has informed Learned Counsel for the respondent regarding her prayer for adjournment, who does not have any objection to the same. Hence, the prayer is allowed. Let this matter be listed after 2 weeks on a date to be fixed by registry.
Obliged. So a prayer for listing a make appeal in orders following. Any that as per convenience for short.
3rd of August.
May I please, Lordship? Lordship, I am praying for listing of a RSA for hearing, Lordship. On several times, Lordship, hearing took place, and last hearing took place on 6/11/25, directed to list the matter after 4 weeks. And 8 months already been passed, Lordship. So, Lordship, in the last stage of hearing, Lordship, any convenient date
5th
in
of
the
August.
next month.
5th of August.
I purpose.
May I please, Your Honor? I beg to mention listing for an old CRP matter, which is fixed for hearing, Your Honor.
Orders of due. 4th August.
May I please your lordship? Lordship, I would beg for listing of 2 MSc appeal in the orders column.
5th of August.
Lordship, I beg to mention item 50. In item 50, mine, I sought for the Vakalatnama. They are not
50 has been mentioned.
mentioned. But my name may be deleted. I will not be appearing because respondent number 1, which is BP Bora.
50, your name is not there. Respondent number 1, okay. 50th, Likhibo. Mr. BP Bora, Learned Counsel for the respondent number 1 has submitted that respondent number 1 has engaged another set of counsel, hence his name may not be reflected in the cause list as engaged counsel for respondent number 1. The prayer is allowed. Registry to do so. List accordingly.
May it please your lordship, I beg to mention listing of 2 RFA matter in the orders column, your lordship. In the first week of August.
5th of August.
Much obliged.
Item number 9, my name has not been shown for the FLM. So I could not bring the file today. Can it be posted next week, my file?
Okay. Mr. A. Bhattacharya, Learned Counsel for the appellant, submits that since his name has not been shown in the cause list today, he could not prepare the case and hence prays for listing this matter after a week. The prayer is allowed. Registry is directed to reflect the name of Mr. A. Bhattacharya as the engaged counsel for the appellant in the cause list henceforth.
I have taken concert with the other side of. Like,
May it please your lordship, I have intervention for listing of a CRP lordship on Monday lordship 27th.
Why?
Lordship.
What is the urgency?
The urgency will lordship here, there is a requirement of completion of service lordship. So lordship can be listed.
Then you cannot choose date,
Lordship.
5th of August.
As of list.
Yeah, your worship, as per instruction of the petitioner, my lord, I will be allowed to.
Heard Mr. A. Mubarak, learned counsel for the petitioner, who submits that he has been instructed by the petitioner to withdraw the instant civil revision petition. The prayer is allowed. This civil revision petition is dismissed on withdrawal.
I also there, my lord, one I.
The in view of the order passed in the connected civil revision petition, this interlocutory application is also closed.
May it be lost.
And in this case, while the petitioners, both the petitioners are students, lordship, and they have been arrested on, my lord, 25/2026 and 5/4/6/2026 respectively, lordship. Now forwarded to the judicial custody, my lord, after and on the next day, lordship. Since then, they are in jail, lordship. Now kindly see the FIR, lordship, at page 17, lordship.
Proceed, lordship. I want to state here something, lordship. Here are some DNA has been taken from petition number 1. It has not been there. So I have to, and there is nothing stated why DNA has been taken. Kindly give me some time, lordship, so that I can communicate with the police officials. It may be retained. It may be retained, it may be retained, so that I can know the connection, what is there. Lordship.
We are fixing short date.
My lord, DNA, my lord, is no relation with this case.
Let him take instruction.
That's it, my lord.
Heard Mr. M. H. Ahmed, learned counsel for the petitioner, also heard Mr. K. K. Das, learned additional public prosecutor, who submits that though the case diary has been received, however, on perusal of the case diary, he came to know that DNA of petitioner number 1 has been collected by the investigating officer. However, without any indication as to what is the relevance of collecting the said DNA. Hence, he seeks some time to get some instruction, get some relevant instruction from the investigating officer in this case before he makes his submission. The prayer is allowed when? Next week.
But Monday, my lord.
31st of August.
28.
28.
All right. Yes.
Lordship, as per office note dated 16/7, lordship, the respondent number 3 is served, 1 and 2 are already served. And trial court record is also received, lordship, a photocopy of trial court record, lordship. So it's ready for hearing.
Heard Mr. A. J. Soikia, learned counsel for the appellant. Also heard Mr. S. Islam, learned counsel for respondent number 1 and 2. On perusal of the office note dated 16/7/2026, it appears that notice issued to respondent number 3 have been duly served. It also appears that the scanned copy of the trial court records have been received. Hence, this case is ready for hearing. Let this matter be listed for hearing after 4 weeks on a date to be fixed by the ministry.
Item 13.
Lordship, matter this case is delayed. There is a delay of, my lord, 872 days. So, my lord, I also requested to the council, the IA numbers 227/18 not furnished to me.
227 or 1132.
Yes, yes. My lord, 1132 I already received.
What is 227?
I don't know, my lord. Or maybe if you
There is
can-
no 227 in this case. None has appeared for the applicant on call. Mr. R.C. Paul, Learned Counsel for the
Item
respondent.
number 1.
Item number
Item number 13. Yes,
13. Respondent number 1 is present. Let this matter be listed after a week on a date to.
After, my lord, I filed my application regarding the delay. After 4 weeks.
Learned Counsel for the respondent prays for some time for filing written objection against the delay condonation application. The prayer is allowed. Let this matter be listed after 4 weeks on a date to be fixed by registry.
That's okay.
Item 14.
May I please your lordship? As per the office note, respondent number 1 could not be found in the given address. It is a matter of enhancement of awarded amount passed by the MSCT Sunitpur. As insurance is the main party, owner's name may be struck off from this matter.
Heard Miss, what is your name?
P. Bordoloi.
Heard Miss P. Bordole, Learned Counsel for the appellant. On perusal of the office note dated 22/7/2026, it appears that notice issued to respondent number 1 has returned without service. Learned Counsel for the appellant submits that respondent number 1 is the owner of the offending vehicle. However, she submits that since this appeal is directed against the quantum of compensation awarded to the claimant, the presence of owner of the offending vehicle may not be necessary for deciding this appeal. Hence, she prays for striking out the name of the respondent number 1 from memo of appeal. Stop. The prayer is allowed. The name of respondent number 1 may be struck off from the memo of appeal. Let this matter be listed after 2 weeks on a date to be fixed by registry in admission column.
Obliged.
Item 15.
Maybe. Last office dated 22/7, my lord. It shows that service is awaited on respondent 1 and 2, my lord. In fact, my lord, we have taken steps for 3 times, my lord. The first notice was on 14/6/2024, my lord. Therefore, may I pray, my lord, we may be allowed to take steps by the substitute.
Speed post, you have taken steps by
Yes,
speed.
my lord.
No, we will ask the registry to place postal track consignment report. One chance.
My lord, we may be allowed to take steps by the substitute paper publication. The matter is pending since 14/6/2024 from the first notice.
What is this in IA for?
IA formula, the first IA is the continuation of delay. In fact, it is a petition for substitution of the legal hearing. There is an office to that person died. We are substituting his son. The respondent 1, respondent 2, once it was in the main appeal, notice was received by his father. The office note dated 15/12/2022 in the main appeal. The address is correct.
Heard Mr. P. Hajorika, the Learned Counsel for the appellant/applicant. On perusal of 1 has been served.
1 and 2, 1 is awaited also.
2 is awaited.
2 and 1, my lord.
Office note dated.
Lordship will see office note dated 28/1/25, my lord. Since then, the R1 and R2 were awaited, my lord.
Office note dated 22/7/2026. It appears that notice issued to the respondent has not returned. Stop. The learned counsel for the appellant prays for allowing the appellant / applicant to take steps for issuance of notice upon the respondents by substituted mode of publication of the notice in the newspaper. The prayer is allowed. The applicant / appellant shall take steps within 2 weeks from the date of this order. The date of appearance to be shown in the notice shall be 28th of August.
My lord.
List accordingly.
Lordship. The Lordship will mention the R1 and R2, my lord. Respondent 1 and 2.
Yes.
For the both the
How many respondents are there?
there are 3 respondents. One company has appeared.
Respondent or within bracket R1 and R2. Respondent number 1 and respondent.
My lord. Obliged.
Item 16.
May I please, my lord? As for office note dated 22/7, R1 is not served. And although R2 service report received, but it is not known who is it. Here the difficulty on our part is that, my lords, they have filed execution proceeding. So may I take steps by speed post?
Heard Mr. A. Bhattacharya, learned counsel for the appellant. This is delay connotation.
Yes.
Learned counsel for the applicant. It appears that the service report in respect of notice issued to respondent number 1 is awaited. Stop. It also appears that AD card issued along with the notice sent to respondent number 2, though has returned, the signatures thereon are not identifiable. Stop. As such, learned counsel for the applicant prays for allowing the applicant to take fresh steps for issuance of notice on both the respondents by speed post. The prayer is allowed. The applicant shall take steps for issuance of notice upon the respondents by speed post within 7 days from the
3 days,
date,
madam.
within 3
we have
days from the date of this order, returnable on 28th of August.
Can it be preponed, madam? We have the urgency.
Suggested date, 14th of August.
Before 15th.
14th of August.
Obliged.
In item 15, my lord, will take steps in the vernacular published from Gauhati. That will
Okay. Go item 2. Publication of the notice in newspaper or agot lekhibo vernacular newspaper.
published from Gauhati. Obliged.
Item 17.
Here, my lord, office note 22/7 says R1 appeared and R2 SR awaited.
Yes, you are appearing for?
Respondent number 1.
Heard Mr. A. Bhattacharya, learned counsel for the applicant. Also heard Mr. A. Hussain, learned counsel for respondent number 1. Respondent mane opposite party number 1.
Here also he has filed execution proceeding before 11.
The service report in respect of notice issued to opposite party number 2 is awaited. Hence, stop. The applicant is directed to take fresh steps for issuance of notice upon respondent opposite party number 2 by speed post within 3 days from the date of this order, returnable on 14th of August.
Much obliged.
May I please, your lordship?
Yes.
Lordship, we have taken necessary filed necessary affidavit yesterday. Lordship may direct registry to kindly put on record.
Heard Miss D. Hajorika, learned counsel for the applicant, who submits that in pursuant to the directions of this court, the applicant had filed the affidavit in compliance regarding publication of the notice in the newspaper. However, said affidavit is not tagged with the case record. Hence, she prays for directing the registry to do so. Stop. The registry is directed to place the affidavit filed by the applicant along with the record on the next date fixed, 10th of August.
Here, as per office noted, 8/1/26 R124 appeared and R5 is awaited.
Heard Mr. A. Bhattacharya, learned counsel for the applicant. Also heard Mr. G. Bhardoja. What is your name?
On behalf of Mr. G.
B. Deori, appearing for respondent number 1 to 4. On perusal of the office note dated 8/1/2026, it appears that the service report in respect of notice issued to the respondent number 5 is awaited. The applicant is directed to take fresh steps for issuance of notice upon the said respondent within 3 days from the date of this order, returnable on 14th of August.
Item 20. Item 20.
None has appeared for the applicant on call. Miss S. Todi appears for respondent number
3.
Respondent number 3. List this matter after a week on a date to be fixed by this.
Item 21. May please, Lordship, this case was proceeded ex parte, my lord, due to non-appearance. So, my lord,
Proceeded ex parte, it's dismissed for default.
dismissed because of non-appearance. Because my lord, my kindly see, my name is reflected. Lordship is on.
Well, this case is for what?
This when my lord, when the case was filed.
Readmission.
Readmission, because case was filed.
You are objecting.
Yes, Lordship. This is negligence, Lordship.
No.
If Lordship will see, he has taken the plea that his name is shown as Ravindra Chandra Paul. That is his name.
No, I
His
mean,
name is
let me
not
to
shown
say,
as
let me
Arsi
to say,
Paul.
let me to say.
That is why he
Let
will
me to
take
say,
it.
let me
And
to
not
say.
on as
Let him submit. Let him submit.
Yes.
Kindly see this, on that day, first day, the case was listed, a delay application shows Arsipal and then Ravindra Chandra Pal. I also submit. But later on, when the delay was unknown, listed, so his letter is generally submit, name may be short. On that day, because my name is all and along in registered, and registered as Arsipal, not as Ravindra Chandra Pal, all along.
So you are not Ravindra Chandra Pal.
Chandra Pal, I am Ravindra Chandra Pal in the call list showing that Arsipal, because it is registered. My lord, I'm showing.
No, Mr. Paul.
Yes, my lord.
When in the cause list on that particular day, it is reflected as Ravindra Chandrapal. How it escaped
My
your
lord,
notice?
Because I'm always seeing Arsipal.
So if your full name is
No,
there, you
not-
will ignore it.
And I'm not, because my name is coming, because I'm registered my name as per my enrollment, Arsipal. My lord, kindly see the page 22.
So if anybody calls you Ravindra Chandrapal, you will not respond.
It is general name, but in the cause list, especially in the cause list, date of my practice, And also I enrolled.
No, reasoning is not very convincing.
Wait for some
allows
time.
it, it should be.
22,
possible.
in this series of cases, now one case is fixed on 3rd of September. In all the cases, after delay condemnation, my name is showing because automatically I'm showing my lord on lordship. This case also first day listed after condoning the delay. Lordship also give it time. Kindly see this page 22. This I bought it in how my name is coming in the RC file instead of Ravindra Chandra Pal. This is details, my lord. It is called CIS database, case information system. Because I will bought it from the registry, computer section. Because my name never come in there. Because this particular 3 cases is defective. When it is registered.
No, sir. What is your submission now?
My submission is that, my lord, there is a no negligence, no part of my side, but it is some inadvertent mistake. My name is appeared as Ravindra Chandrapal. That is kindly see, my lord, first day when it is.
So it escaped your notice.
My lord, yes, exactly, my lord. This is escape. What is one day the one case, my lord? I'm giving
Yes,
the
Mr.
sample. I'm giving the, my lord. Kindly see page number 31. On that day also, my lord, this case, one case is also fixed for hearing lordship case, lordship court.
No, it may happen sometime.
Happening, my lord.
But not on it may happen on a single day.
No,
days.
that is why, and the 3 days, 3 days
days.
come as RCPA.
Because claimants are suffering, lordship. They file
Maybe,
appeal and
maybe,
they negligently they do not.
maybe, not negligent. Or how you can say it is
his name is Ravindra Chandra Paul.
Maybe.
So how
I
he
am
can
not
escape
concerned about the
lordship?
Ravindra Chandra. I am
My
concerned
full
all
name
along in
is
the
found
cost
in the
list as
cause list.
RCPA.
I cannot.
I am a habituated RCPA,
Yes.
not habituated Ravindra Chandra.
Then you write everywhere.
That is why I make it myself is short.
Give a declaration.
That is my thing. Kindly see, my lord, kindly see this.
No, though your submission is not at all convincing.
All of
but
my
I-
lord, this is my habituated, because
No, you change your habit. If somebody calls you by
nowadays
your
I
name.
have changed lordship has said, I've changed because I am acquainted with both the name. Kindly see, page 31. I also appear
We
before
are allowing, but not because of your submission.
kindly
Otherwise,
see, that day, annexure, page 31. I also appeared before this on a particular this on a record.
heard Mr. R.C. Paul, learned counsel for the applicant. Also heard Mr. A.F.N.U. Also heard Mr. M. Ahmed.
My name is not reflected, but it's in the.
Learned counsel for the respondent / claimant. This application under Order 41 Rule 19, read with Section 151 of the Code of Civil Procedure, has been filed by the applicant insurance company for readmission of connected MAC appeal number 598/2025, which was dismissed for default on 5/6/2026 due to absence of engaged counsel for the applicant when the matter was called by the court. Learned counsel for the applicant submits that since on the date when the connected appeal was dismissed, the name of the engaged counsel of the applicant was shown in the cause list as Ravindra Chandra Paul, which is in fact the name of the engaged counsel. However, he submits that since in all his appearance before this court, his name is reflected in the cause list as Mr. R.C. Paul, and therefore he is habituated in looking for the name of R.C. Paul in the cause list, and thus he missed his name in the cause list. Learned counsel for the respondent, Mr. M. Ahmed, has vehemently opposed the prayer for readmission on the ground that when the actual name of the engaged counsel is Mr. Ravindra Chandrapal, he cannot take plea that his name has not been shown in the cause list. Hence, he submits that the counsel has shown gross negligence in going through the cause list and not appearing before the court when the matter was called. Hence, he opposes the readmission of the connected appeal. I have considered the submissions made by learned counsel for both the sides. Considering the fact, after considering the averments made in the petition, it appears that the engaged counsel for the applicant is habituated in looking for his name in the cause list with abbreviations R.C. Paul instead of Rabindranath Paul. Ravindra Chandra Paul. Hence, though apparently there is a lapse on the part of the engaged counsel for the applicant, however, same is possible same is not entirely impossible, as said lapse may genuinely happen on some occasion. As such, the instant interlocutory application is allowed and the MAC appeal number 598/2025 is readmitted. The registry is directed to list the connected MAC appeal on.
My lord, analogous case is fixed, my lord.
When?
Fixed on another case, but because
When?
3rd of September.
It's very long date, Lordship.
3rd of
The agreement
September.
is after she has need to receive anything, Lordship.
3rd of
Let it be next
September,
week, Lordship.
there is a 2 analogous cases.
21 August.
Yes.
3rd of, not
What?
September, 3rd of August, 3rd of August.
Matter is
Okay.
admitted.
I mean, 3rd of August.
3rd of August.
3rd of August. Another, my lord, along with this, another case also. All the cases are defectively, my name is shown. I could not appear. MAC appeal number, my
No,
lord.
it is not defectively shown.
No,
Your name is correctly shown.
correctly shown, but I'm not habituated in the.
You change your habit,
My
what I have
another
said.
appeal, connected appeal,
The-
the 423/25.
You are lucky that I am not imposing cost
My
on
lord,
this.
I'm obliged, my lord. My lord, another appeal also. Another case also.
No, not in this.
Connected, my lord. Analogous case.
I am fixing this matter on 3rd of.
3rd of August, that one case is there, another case also, along with this appeal.
So what do you want?
But both, all the 3 cases come together for admission.
It will come on 3rd of August.
Yes,
On
yes.
that day, you may mention to take up the matter
My lord,
together.
much obliged.
Item number?
May I please, Lordship? It's a application for violation of injunction order, madam. In the last order, my lord, 31(3). Your Lordship was pleased to fix the matter along with the main appeal, my lord. Main appeal was already been heard once, my lord. May I pray, my lord, as per that order, my lord, that matter I'm fixed in hearing column, my lord. Because already the appeal which was pending, my lord, along
No,
with
but this relates to an RSA.
yes, my lord. Second.
RSA, a different bench is taking up the matter. This. No, this Aji. Okay. What is your prayer?
Prayer is that, my lord, then present my lord, my lord, should be fixed with the main appeal, my lord. Main appeal to be heard, my lord. It was order reflected, my lord, order 30.
This was the order on last occasion.
Yes, 31(3). That was the order, my lord, with the second appeal, my lord. It was instead of, my lord, for hearing, my lord, it was listed for order column.
Heard Mr. Sheila Datta, learned counsel for the applicant. Also Miss
M. Nath.
M.A. Nath, learned counsel for the opposite party. Learned counsel for the applicant submits that on 31/3/2026, it was directed by this court that this interlocutory application may be taken up along with the connected regular second appeal number 68/2012 when the said matter may be taken up for hearing. However, instead of doing so, registry has listed this matter in the orders column. He prays for listing the connected regular second appeal for hearing along with this interlocutory application. The prayer is allowed. Let this matter be listed. Date that. When do you want?
Last part of August, Lordship.
September 3rd. 3rd of September.
Third option.
3rd of September.
Can it be on my lord? Obliged.
May I please your lordship? Lordship, we are unable to trace the correct address for the respondent. Lordship may kindly permit us to take steps through paper publication.
Ms. D. Hajurika, learned counsel for the
Fix
appellant,
after 2 weeks.
who submits that in spite of efforts being made, the appellant is unable to correct the correct address of respondent number 1. Hence, she prays that the appellant may be allowed to take steps for issuance of notice upon respondent number 1 by substituted mode of publishing the notice in one vernacular newspaper circulated widely in the last known address of the respondent number 1. The prayer is allowed. The appellant shall take steps accordingly within 2 weeks from the date of this order. The date of appearance to be reflected in notice shall be 3rd of September 2026. List accordingly.
This case is, I'm the respondent number 1, already admitted.
How many respondents are there?
A quantum. This appeal has been filed for quantum.
How many respondents are there?
You are not to respond.
2. Okay.
I'm
Heard Miss, what is your name?
A.G. Chaudhary, your lordship.
Heard Miss A.G. Chaudhary, the learned counsel for the appellant. Also heard Mr. R.C. Paul, the learned counsel for respondent number 1. It appears that notice to the parties, issuance of notice to the parties in this appeal is complete, and the records of the concerned MSC case has also been received from the concerned Motor Accident Claims Tribunal. Hence, this appeal is ready for hearing. Let this matter be listed for hearing after 4 weeks on a date to be fixed by registry.
That's okay, lordship.
May I please be lordship? Lordship, according to office note dated 22/7/26, service of R1, R2 and R3 is complete, lordship, and TCR has also arrived, lordship.
Heard Mr. A. Agarwala. A. Agarwal or Agarwala?
Agarwala, lordship.
Heard Mr. A. Agarwala, learned counsel for the appellant. Also heard Mr. T. Kolita, the learned counsel for respondent number
1.
Respondent number 1. It appears from office note dated 22/7/2026 that notice issued to Respondent number 2 and 3 are also duly served. Hence, further it also appears that the records of MAC case number 1865/2021 have also been received. Hence, this appeal is ready for hearing. Let this matter be listed for hearing after 4 weeks on a date to be fixed by registry.
Obliged, Lordship.
May please, Your Lordship. So, office note indicates Lordship service is complete against the Lordship 1, 2, 3, 4, and 6, and 5 has been shown as died Lordship. The last office note is 22/7.
5 has expired.
Lordship. Office note indicates Lordship.
So,
Lordship, he is a driver and owner is already in party, Lordship. We are Lordship ready to make them party other legal hearings. The information has to be Lordship, somehow we are collecting.
you will take steps.
Lordship, we have to take.
Heard Mr. J. Kolita, learned counsel for the appellant. Also heard Mr. R.K. Bhatra, appearing for respondent number
3, man.
respondent number 3, as well as Ms. J. Akhtar, appearing for respondent number 1 and 2. It appears from the office note dated 22/7/2026 that the notice issued to respondent number 5 could not be served as he has been reported to have expired. Staff learned counsel for the appellant submits that some time may be granted to the appellant so that appropriate steps may be taken in respect of respondent number 5. The prayer is allowed. Let this matter be listed after 2 weeks on a date to be fixed by registry.
The copy of
UFA.
Take matter item
55 years. Supplementary.
We have filed cross objection, Lordship.
55.
Yes.
After 2 weeks, along with MAC, and after 2 weeks, along with cross objection number 12/2026 in 55. This cross objection has been filed by the your claimant by the claimants/cross objectors in connection with MAC appeal number 140/2026. Mr. J. Kolita appears for the Oriental Insurance Company Limited, whereas Mr. R.K. Bhatra, learned counsel, appear for New India Insurance Company Limited. The cross objectors shall take steps for issuance of notice on remaining 2 respondents by speed post within 7 days from the date of this order, returnable on 21st of August. List accordingly.
Obliged.
I go to 21st August. It can be.
Item 27.
May it please your Lordship. Lordship, in this case, we have filed one amendment petition, Lordship, that is numbered as IA number 2433 of 2026. Lordship, let it come on Monday with that IA, Lordship.
Heard Ms. Adi Majumdar, learned counsel for the appellant, who submits that the appellant has filed an interlocutory application seeking amendment of the memo of appeal, which is numbered as
IAC in bracket 2433/2026.
Likha. She prays for listing the said interlocutory application along with this appeal on the next date fixed. The prayer is allowed. Let this matter be listed again on Monday,
27.
27.
Highly obliged, Lordship. Lordship, here, Lordship, as per office note dated 21/7/26, notices are sent by usual and speed post and LCR is called. So we have to await for the postal track report.
Heard Miss Adi Majumdar, the learned counsel for the appellants. On perusal of the office note dated 21/7/2026, it appears that the service report in respect of notices issued to the respondent is awaited. The registry is directed to place the postal track consignment report of notices issued to the respondents by speed post. The registry is further directed to issue reminder for the records of the MAC case number 962/2022. List this matter again, 12th of August.
Hello.
29.
Lordship, in this case, respondent number 1 to 4 has appeared, Lordship. I will be allowed to take step upon the respondent number 5 and 6. So I am paying in 3 days time.
Heard Mr. K.K. Bhatto, the learned counsel for the appellant. Also heard Miss
M. Ghazlu.
M. Ghazlu,
And for respondent number 1 to 4.
the learned counsel for respondent number 1 to 4. Learned counsel for appellant prays for allowing the appellant to take fresh steps for issuance of notice to respondent number 5 and 6. Prayer is allowed. The appellant shall take steps for issuance of notice upon respondent number 5 and 6 by speed post as well as by usual mode within
3 days.
within 3 days from the date of this order, returnable on 26th of August.
Need please, your Lordship. Lordship, as per office noted dated 22/7/2026, Lordship, service of respondents are awaited, Lordship. In item number 31, also same, Lordship.
Heard Miss F. Begum, the learned counsel for the appellant. On perusal of the office note dated 22/7/2026, it appears that the service report in respect of notices issued to the respondent is awaited. The registry is directed to place the postal track consignment report of the notices issued to the respondents by speed post before this court on the next date fixed. Let this matter be listed on 14th of August.
Wait, please, your Lordship. In this case, LCR has been received, my lord. Service report with respect to R1 to R3 are awaited, my lord. We have taken steps. R3 appeared. Okay. Oh, sorry, R3 has appeared, Lordship. R1 to R2, Lordship. So, registry is directed to place the track consignment report.
Heard Mr. A. Lal, learned counsel for the appellant. Also heard Mr. S. Sharma, the learned counsel for respondent number 3. On perusal of the office note dated 27/2026, it appears that service report in respect of the remaining respondents is awaited. Stop. The registry is directed to place the postal track consignment report of notices issued to respondent number 2 and 3 by speed post before this court on the next date fixed. Let this matter be listed. 14th of August.
43.
May I please, Lordship? In this case also, as per office note dated 22/6/2026, Lordship, services of the respondent number 1, 2, 3 are awaited, Lordship.
Heard Ms. D.D. Burman, the learned counsel for the appellant. On perusal of the office note dated 22/7/2026, it appears that the service report in respect of notices issued to the respondents is awaited. The registry is directed to place the postal track consignment report of notices issued to the respondents by speed post before this court on the next date fixed. Let this matter be listed. 14th of August.
Item 34.
May I please, Your Lordship? This is, the share has been received and I have taken step upon the respondent, but they are not appeared.
Heard Mr.
H.
Ahmed. H.R. Ahmed.
H.A. Ahmed.
H.A. Ahmed, the learned counsel for the appellant. On perusal of the office note dated 22/7/2026, it appears that the service report in respect of notices issued to respondent is awaited. Stop. The registry is directed to place the postal track consignment report of notices issued to the respondent by speed post before this court on the next date fixed. Let this matter be listed. 14th of August.
Item 45.
May please, Your Lordship. Lordship, as per office note dated 22/7/26, no ID card or unserved notice in respect of respondent number 1 and 2 has arrived. Unserved notice in respect of respondent number 3 has arrived with insufficient address. Lordship may kindly give some time. I'll ascertain the appropriate address if there is any in respect of respondent number 3 matter.
Heard Mr. M.M. Zaman, the learned counsel for the appellant. It appears on perusal of the office note dated 22/7/2026 that notice issued to respondent number 3 has returned with a postal remark within inverted comma insufficient address. Stop. Return to sender inverted comma close. And as regards other respondents, the service report is awaited. The registry is directed to place the postal track consignment report of notices issued to respondent number 1 and 2 by speed post before this court on the next date fixed. The learned counsel for the appellant has prayed for some time to ascertain any alternative address of respondent number 3 before thereafter to take steps again. The prayer is allowed. Let this matter be listed again. 24th August.
Can I be on September, my lord?
3rd of
Possible.
September.
Obliged, Lordship.
Item 46.
May it please, Your Lordship. Lordship, in this case, my claim for compensation was dismissed, Lordship. There is some urgency in the matter, my lord. Service report is awaited. I pray that I may be allowed to take fresh steps by Dusty, my lord, on respondent number 1 and 4, and usual process against all the respondent again. Speed post, the registry may be directed to place track record, my lord. Consent track consignment. You are paying for?
I'll for respondent number 3.
3.
I will file my avocado for the daily report for the day.
Heard Mr. A. Lal, learned counsel for the appellant. Also heard Mr. R. Boro, appearing for respondent number 3, who submits that he will be filing his wakalatnama during the course of the day. On perusal of the office note dated 27/7/2026, it appears that service report in respect of notices issued to the respondents is awaited. Learned counsel for the appellant submits that the appellant may be allowed to take steps additionally for issuance of notice upon respondent number
1 and 4 through Dusty
1
Mode
and 4 by Dusty Mode
and 3 to again by speed
and
mode. Sorry, usual process by 2 and 2.
by and against 3 by usual
No,
mode.
2 lots. 3 has already happened.
Against 2 by usual mode. The prayer is allowed. The appellant shall take steps accordingly within 7 days, returnable on 28th of August. Stop in the event the appellant is able to serve the notice by Dusty Mode on respondent number 1 and 4, he shall submit an affidavit in compliance thereto on the next date fixed, list accordingly.
Reminder for LCR, LCR also wrong.
The registry to issue reminder for the records of MAC case number 2586/2017.
I voted.
May it please, Lordship. Hearing this case, Lordship, service is complete, Lordship.
This is condonation.
Delay, Lordship.
How much delay?
248 days.
Oh, 2.
248 days, Lordship.
Yes, Mr. Sakya.
Actually, they have taken the ground that among others, that financial crisis was the reason for their delay also. But we had already paid the amount on, let's say, 4,06,099.
Lordship, my main ground is disability. Due to disability, could not come in time.
And another thing, Lordship, in paragraph 4 of their petition, they have written that case was filed on 23/1/25, but on searching the, let's say, website, it's seen that it is filed on 4/8/25. So there may be some anomalies.
What disability you are suffering?
45% disability, Lordship, it is, I have annexed the disability certificate.
Yes. What was your last point, Mr. Sakya?
Lordship.
Second point.
Lordship, it is written in their petition paragraph 4 that case was filed on 23/1/25, but on online check, Lordship, from the website, it is seen that it is filed on 4/8/25. So it is maybe different.
4/8/25.
4/8/25 as per online checking. So there may be some problems. Which is correct, Lordship, it is to be a settlement.
APT was filed on 22/1/25, Lordship.
Yes. Seal is of 27 January 2024. So it was filed in the month of January. (27/1/2025).
That shows some different date. It's fine.
Still you have mentioned wrong date. It is not 23, 27/1/20. Any other objection?
In my petition, it is 23. Paragraph 4 also. Of the petition.
23/1.
Yes, Mr. Sakya. Any other?
These are their, my submission that their explanation is not proper, let's say.
It is for enhancement.
Lordship, disability is 45%, but Lord Learned Tribunal consider 10% loss of functional disability.
Heard Mr. M. Talukdar, Learned Counsel for the applicant. Also heard Mr. A. J. Soikia, the Learned Counsel for the respondent insurance company. This application under Section 5 of the Limitation Act 1963 has been filed by the applicant / claimant Muhammad Abul Qasim, praying for condonation of delay of 248 days in filing the connected MAC appeal, whereby the judgment and award passed by the Motor Accident Claims Tribunal Morigao in MSC case number
MSc injury case number
57/2017 on 19/2/2024 has been impugned. Learned Counsel for the applicant has submitted that he has mentioned the reasons for delay in filing the connected appeal in paragraph number 3 to 5,
3 and 4.
3 and 4 of the instant interlocutory application. He further submits that since the applicant suffered from this physical disability to the tune of 45%, however, the tribunal has assessed the functional disability only at 10%, and hence he is aggrieved with the impugned judgment and award and seeking enhancement of the same. Learned Counsel, on the other hand, Learned Counsel for the Mr. A.J. Soikia, Learned Counsel for the respondent number 3 submits that the date of filing the connected appeal has been mentioned wrongly in the instant interlocutory application as 23/1/2025, whereas in the information available on the website of this court, it has been shown that the date of filing of the appeal is 4/8/2025. He further submits that though the applicant has taken the plea of financial difficulty for not preferring the appeal within prescribed time, however, he submits that the insurance company has already paid rupees
4,06,959.
4,06,959 to the applicant, and as such, the plea of financial difficulty is unsustainable. I have considered the grounds stated. I have considered the submissions made by Learned Counsel for both sides. On perusal of the records, it appears that the connected appeal was presented before the registry on 27/1/2025. It also appears that the ground taken by the applicant in the connected appeal may be required to be adjudicated. Hence, the grounds stated for the delay caused in preferring the connected appeal in the instant interlocutory application is regarded as sufficient cause by taking a liberal view of the matter, and the delay caused in preferring the connected appeal is hereby condoned. So this interlocutory application is accordingly disposed of. Registry is directed to register the connected appeal and list the same for admission after a week on a date to be fixed by it.
Our name may be shown.
Name of Mr. A.J. Soika may be reflected as engaged counsel for respondent number 3 in the cause list.
Other advocate have also filed their occurrence number, Lordship. Other somebody is also there. Your name may be also shown.
Okay. And now we will issue notice, or on that day we will see.
How like? Item 38.
May it please your lordship. Pleases your lordship. As per office note dated 22/7/26, lordship, service is complete, lordship. And this is a delay application.
Delay application.
Yes, lordship.
How much delay?
204 days, lordship.
You are opposing?
I am appearing for respondent number 5, lordship.
Insurance.
Insurance company, lordship.
You are opposing?
Not opposing as such, lordship. Only the thing is that, lordship, because of the council, the delay occurred in paragraph 3, it is stated, lordship. And council has
Heard
made
Ms. R.D. Mujumdar, learned counsel for the applicant. Also heard Ms. M. Chaudhary, learned counsel for respondent number 5. It appears from office note dated
22/7/2026.
22/7/2026 that the notice issued to other respondents
1 received by father, 2 received by wife, 3 received by brother, 4 received by brother.
are duly served. Stop. Hence, duly served. Stop. Today, apart from respondent number 5, no other respondent is being represented before this court. However, this court is inclined to proceed ex parte against them in this interlocutory application. This interlocutory application under Section 5 of the Limitation Act has been preferred by the applicant, namely Oriental Insurance Company Limited, claim for condoning the delay of how many days?
204 days.
204 days in preferring the connected MAC appeal. The learned counsel for the applicant has submitted that the applicant has stated the reasons for delay in paragraph number
3 to 7.
3 to 7 of the instant interlocutory application. Yeah. What is your submission, Ms. Chaudhary?
Otherwise, it's a procedural delay, and paragraph 3, it's for only for council. It took time to submit the certified copy. After 6 months, it took, lordship. Therefore, lordship, because of the council, the delay occurred, lordship, and the council was not made part in the procedure.
Are you opposing?
I am not opposing as such, lordship. Only I pointed. I have pointed. Lordship may not write that I am agreed to that, lordship.
Vehemently opposed.
Yes, vehemently opposed.
Chaudhary, learned counsel for respondent and 5, points out that on perusal of the interlocutory application, it is apparent that delay has been caused due to the engaged counsel for respondent number 5 in preferring the connected appeal.
No. For applicant, they have not filed. advocate for the applicant.
Delay has been caused due to has submitted that no, not respondent number 5. Applicant, stop. I have considered the submissions made by learned counsel for both sides and have gone through the grounds stated by the applicant for delay in approaching the court, this court for filing the connected appeal. Stop. Considering the grounds stated therein to be sufficient cause which resulted in delay in approaching the court by filing the connected appeal, the said delay of 204 days is hereby condoned and this interlocutory application is allowed. The registry is directed to register the connected MAC appeal and list the same for admission after a week on a date to be fixed by it. List accordingly. Name of Miss M. Chaudhary may be reflected in the cause list as engaged counsel for respondent number 5 henceforth.
Hello, Black. Stop, please. Item 39. 39, Lordship, as per office note dated 22/7/26, respondent 1 and 2 file wakalatnama, 3 received by Manas Malakar in presence of witness. For 4, Lordship, registry has given no AD, but we had taken step by speed post, Lordship. So registry will get the.
Okay.
Otherwise, this is a delay petition and
Heard,
delay of 127 days.
heard Miss Adi Majumdar, learned counsel for the applicant. Also heard Mr. M.S. Laskar, M.H. Laskar, appearing for respondent number 1 and 2 / claimants. It also appears from office note dated 22/7/2026 that the notice issued to respondent number 3 has been served on one of his family members. Hence, same is held to be duly served on the respondent number 3. Stop. The service report in respect of notice issued to respondent number 4 is awaited. Stop. The registry is directed to place the postal track consignment report of notice issued to respondent number 4 by speed post before this court on the next date fixed. Place this matter before on 14th of August.
Hello. Item 40, Lordship, the I-1366, that is stay petition, they have mentioned it, Lordship, whereas the delay is still pending.
No.
Yes, you have mentioned.
I have mentioned 2/5.
No, by order is that. By order is stay
Yes,
petition.
but stay petition will be dealt with later on.
Yes,
My lord, stay petition will be later on, my lord. My lord, my submission before your lordship,
2514.
2514. My lord, I am for the, my lord, respondent claimant side.
13 days delay only,
You are
Lordship.
not opposing.
My lord, 13
Okay.
days.
Heard Miss R.D. Majumdar, learned counsel for the applicant. Also heard Mr. Yes, your name.
Stay mention করিস আপনার নাম তো কোন
Mr. A. Mannaf, learned counsel for the respondent / respondent number 1, 2, 3 / claimants. This application under Section 5 of the Limitation Act has been filed by the applicant Oriental Insurance Company Limited, praying for condonation of delay of 13 days in preferring the connected MAC appeal. The reason for delay has been stated in paragraph number
3 to 8.
3 to 8 of the instant interlocutory application. Mr. A. Manaf, learned counsel for the respondent/claimant, submits that considering the short period of delay and grounds stated in the instant interlocutory application, he has no objection if the said delay is condoned by this court. After considering the submissions made by learned counsel for the parties and after going through the grounds stated in the interlocutory application, this court is of opinion that the applicant insurance company was prevented by sufficient cause in preferring the connected MAC appeal within the prescribed period of limitation. As such, the delay of 13 days in preferring the connected MAC appeal is hereby condoned, and this interlocutory application is allowed. Registry is directed to register the connected MAC appeal and list the same for admission on 10th of August.
My name may be shown in the.
Name of Mr. A. Manaf may be shown in the cause list as engaged counsel for respondent number 1, 2, and 3 henceforth.
Item 41.
May please, sir.
Yes.
Lordship, I have filed this instant IA. Lordship, here in applicant is a claimant, Lordship. Lordship,
Whether stay has been granted?
no, Lordship, stay has not been granted, but I have made a statement, Lordship, as a record has been called for and already is received. So, Lordship, that's why, Lordship, execution proceeding is not in possible, Lordship. Lordship, here in this appeal, Lordship, the main contention is Lordship, the.
No, why this IA has been filed?
Lordship, after filing of, after passing of this order, Lordship, there is 13/3/2026, Lordship.
What this order says?
Lordship, in this order, Lordship, this appeal has been admitted, Lordship, and record has been called for.
So what modification you want?
Lordship, modification is, Lordship, that's in this appeal. Their contention is, Lordship, that policy condition has been violated. So, Lordship, if it for sake of argument is admitted, Lordship, then Lordship, pay and recovery options will come. So, Lordship, here in this applicant is the claimant, is the third party. Lordship, he should not be sufferer, Lordship. So that's why 50% amount or Lordship judgmental amount has to be.
No, but they are not paying for stay. Is there any stay?
Lordship, stay petition IA is there. That
We did not on the day it was. Moreover, I'll submit on his application itself. Where is the provision for Lordship to direct? They can go for execution. It is not necessary. And also his submission, the court has not even mentioned our evidence, Lordship. In paragraph 8, the court is mentioning that we have given evidence, but there is no reason, nothing, no. It will be
No,
ultimately.
therefore appeal is required to be
Yes,
heard.
it is to be heard, Lordship.
Appeal is required to be heard expeditiously.
Yes.
How we can modify order dated 13/3/26?
Lordship, as because Lordship, ultimately, Lordship, what my submission is that, Lordship, that their contention is a violation of this policy conditions. That then, Lordship, it will become pay and recovery options. So, Lordship, in this case, the tribunal did not given pay and recovery options. So, my submission is that, Lordship, if this some relief has to be given to the third party. Otherwise, Lordship.
No, you can go for execution. There is no bar.
Lordship, that's why my statement is there. Lordship, that record already came, Lordship. So already received by this court. So petitioner, applicant is not in position to file an execution proceeding, as because record is not available before the tribunal, Lordship.
make appeal, sir.
This order, Lordship, it is a statutory appeal, Lordship have admitted. There is nothing wrong in this. I do not know what modification
This 13.3 order,
does not suffer from any infirmity.
yes, what modification?
Lordship.
You can press for this prayer when they go for pressing their stay petition.
Lordship, my submissions, Lordship. On that day, Lordship, this court also advised me, Lordship, then I have to file the execution proceeding. But here, Lordship, the record already came, already received by this, before this honorable court. So,
So it can be,
execution
Lordship finally heard. I do not mind.
You are not pressing for stay.
Right now, I'm not pressing Lordship because Lordship, the court has not even mentioned. Ultimately, it will be remanded back. When the court has not examined what evidence we have given, court has not even one line is mentioned in the judgment.
Lordship.
No, I am not on that.
Yes. Lordship,
If I have understood your query. This IA is to be dismissed. This IA does not have
Any locus.
valid ground for interfering in that.
Lordship,
But if they don't go for stay, you go for execution.
So, Lordship, Lordship, then and liberty may be given, then the tribunal can create the record, and my application will be considered. Otherwise, Lordship, record is not available before the.
No, we'll direct the registry to send a photocopy of the records to the tribunal.
Lordship.
Heard in appeal. Heard Ms. Adi Majumdar, learned counsel for the appellant. Also heard Mr. I. Hawk, learned counsel for respondent number 1. It appears that on 3/6/2026, the service of notice on respondent number 3 was deemed to be duly served by this court. However, notice upon respondent number 2 is still awaited. Service report of notice issued to respondent number 2 is still awaited. The appellant is directed to take fresh steps for issuance of notice upon respondent number 2 by speed post. It was insufficient address.
Because he is the owner of the vehicle and otherwise newspaper, Lordship. Because the address which is given in the claim petition, that is the address we have.
Substituted mode of
Lordship, just I would mention one thing, Lordship. I have gone through this record. If the owner has filed his written statement in his affidavit, Lordship, he is mentioned his address. Some a little bit difference. So, Lordship.
Okay, you verify the correct.
You can take it correct address.
Learned counsel for the applicant submits that some time may be granted to the appellant to ascertain the correct address of the respondent number 2 and to take fresh steps for issuance of notice upon the said respondent by speed post. The prayer is allowed. The appellant shall take steps for issuance of notice upon respondent number 2 in his correct address by speed post within 15 days from the date of this order, returnable on 2nd of September. 1398. This application heard Ms. I. Hawk, learned counsel for the applicant. Also heard Ms. Adi Majumdar, learned counsel for the insurance company. This interlocutory application has been filed by the applicant/respondent number 1 praying for modification of the order dated 13/3/2026 passed in MAC Appeal number 116/2026. The applicant is seeking a direction to the insurance company to deposit the compensation amount, entire compensation amount awarded to the claimant/applicant before this court, and thereafter to disburse the same for in favor of the applicant. Learned counsel for the insurance company, Ms. R.D. Majumdar, submits that the order dated 13/3/2026 sought to be modified by this application suffers from no infirmity, as by the said order the appeal was admitted and notices were issued to the respondents. She further submits that though the appellant insurance company has filed the stay application, but stay applications are but not in the said stay application, notices have been issued and no stay has been granted till date. She submits that the said stay application IA number 794/2026 may be considered on its own merit after appearance of the opposite parties, and this instant interlocutory application may be dismissed. This court finds force in the submission of learned counsel for the applicant, learned counsel for the insurance company, as by the order dated 13/3/2026 passed in the connected MAC appeal, the said appeal was only admitted and notices were issued to the respondents and the records were called for. Hence, same need not to be modified. Same suffers from no infirmity and requires no interference of this court. As regards the submissions made by learned counsel for the applicant, that since the original record of the connected MAC case number
28 of the 22.
28/2022 has been called for and has been sent by the concerned tribunal to this court, the applicant could not pursue the execution case before the said tribunal. Stop considering the submission made by the learned counsel for the applicant. Registry is directed to send back a scanned copy of the records of MAC case number 28/2022 to the Motor Accident Claims Tribunal, Kamrup Rural, so that execution case may be pursued before the said tribunal. With above observation, This interlocutory application is dismissed.
Lordship, can the date be preponed from 2/9 to 26/8?
26/8. Okay.
Highly understood.
Oh, I'm taking a shot.
Lordship, in IA, we have filed an affidavit in opposition. This is not taken with the record, Lordship.
Mr. M. Burman. What is your name?
My lord, Mr. M. Burman is the engaged counsel.
What is your name?
P.H. Burman.
P.H.
Burman.
Kaur, the learned counsel for the applicant. Also Miss S.A. Khalifa, learned counsel for the opposite party, who submits that the opposite party has filed a written objection against the prayer for condonation of delay made by the applicant. However, same is not tagged with the case record. Hence, she prays for directing the registry to place the said written objection along with this interlocutory application. Registry to do so and list this matter again on 10th of August.
May I please, your lordship, in this matter, lordship, as per office note dated 22/7/26, answer of notice has been received in respect of respondent number 4, and service of notice on respondent number 1 and 3 is still awaited. So we may be expected to take steps on respondent number 4 by the service.
One I am repairing, one is the minor. So I'm referring to two is the lordship.
You are appearing for
1 and 2.
1 and 2, 3.
Here I'm not able.
Heard Miss P. Fukon, the learned counsel for the applicant. Also heard Mr. J. Kolita, the learned counsel for respondent number 1 and 2. It appears from office note dated 22/7/2026 that notice issued to respondent number 4 has returned without service with an endorsement. No such person in the address returned to sender. The learned counsel for the applicant submits that the applicant may be allowed to take steps for issuance of notice upon respondent number 4 by dusty mode. The prayer is allowed. The applicant may take such steps within 15 days from the date of this order, returnable on 31st of August. In the event the applicant is able to serve the notice upon respondent number 4 by dusty mode, comma, it shall submit an affidavit in compliance thereto. The registry is directed to place the postal track consignment report of notice issued to respondent number 3 by speed post before this court on the next date fixed. List this matter accordingly on 31st August.
46.
None has appeared for the applicant on call. Let this matter be listed after a week on a date to be fixed by registry.
May please, your lordship. This is an IA preferring condonation of delay for 285 days.
What is your name?
R. Sharma on behalf of Aidher.
Heard Mr. R. Sharma, the learned counsel appearing on behalf of Mr. A. Dhar, the learned counsel for the applicant. This interlocutory application under Section 5 of the Limitation Act has been filed by the applicant for condoning the delay of
85 days.
294 days.
85 days.
It is mentioned 94 here. 294 days in preferring the connected revision petition. Let the notice be issued to the respondents. The applicant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 31st of August.
Item 53 from supplementary list.
Lordship, this case is ready regard to service and LCR, Lordship. So earlier it was listed for hearing, but now respondent number 2 has mentioned the case for 3 times, Lordship, owner of the vehicle. I don't know why.
Heard Mr. A.R. Agarwala, learned counsel for the appellant. Also heard Mr. K.K. Bhatto, learned counsel for the respondent number 1. This appeal is ready for hearing. Hence, list this matter for hearing. Hearing date at the 5th of November.
People, Lordship, I pray for release of the 50% awarded amount deposited. Amount has already been deposited.
Appeal song. Putul appeal. Any stay application has been filed.
Yes, Lordship. Stay has been granted and the amount has already been deposited. My petition is for release of the amount.
But insurance company, no one is present.
Then it may be on 25, 29.
Heard me on first week of
23 respondent.
August. Heard Mr. A.R. Agarwala, learned counsel for the applicant. Also heard Mr. F.A.
No, Lordship, this is another matter, Lordship. The earlier matter that has been hearing, fixed on hearing.
Okay.
It is another matter, Lordship. It is not the matter.
None has appeared for the insurance company. Hence, list this matter again on 3rd of August.
This one, item 3.
This is a injunction appeal, which the defendant has filed before your lordship. It's a dispute between two brothers. Plaintiff has filed the suit for partition, saying that the suit property was actually inherited by both of them, plaintiff and the defendant. And the plaintiff was working in Rangia in Assam, and the property is in Barak Valley, my lord. When he went back after leaving Rangia and requested his brother to partition the property, brother refused, so he has filed the suit. Defendant has filed a written statement counterclaim saying that plaintiff wants to sell his part of the property. If he wants to sell, I want a preferential right. This is the suit. Now we are against the order of.
But he is not against partition.
No, Now what is I'm before your lordship against an order of injunction. Lordship may just have a look at the prayer made in the application. It can be disposed of by small clarification. That is why I'm placing to the lordship. Lordship may kindly have a look at page 27. Not a very big issue, my lord. Page 27 is the injunction application.
Yes, 27 is the miss case.
Page 27 is the injunction application. And lordship may kindly turn to page 31, the prayer. Page 31, the prayer portion. It is therefore, lordship has got manner. Page 31.
Yes.
It is therefore prayed that your honor would be pleased to pass an order of temporary ad interim injunction restraining the opposite party from creating any third party interest over the property mentioned in the schedule below, and also from inducting any third party there, and also from changing the nature and feature of the same till disposal of the suit.
In whose possession land is?
My lord?
Land is in whose possession?
In possession of my client. They are residing there.
Okay.
My lord, what I am saying is, my lord, if the plaintiff has an apprehension that I'm selling, in fact, there is no apprehension. I am residing there with my family members. There is no question of selling. Anyway, my lord, lordship will now kindly see what is the order passed. I'll not go to the entire order, only the operative part at page 52, my lord.
Yes.
Accordingly, for the sake of fair trial and to preserve the suit property, both the parties are directed to maintain status quo in respect of the suit schedule, land, and property till disposal of the main suit. Now, the difficulty with this kind of order is, my lord, the restraint order against me, if it is there, my lord, as a counsel, I'll say, my lord, no difficulty. All right, if both of them have. Lordship will not record my concession. And what I'm saying is, my lord, the status quo order will create difficulty because, my lord, we have mentioned in the appeal. This area is a flood-prone area. My lord, we have got photographs, at least 1.5 feet, sometimes 2 feet, it comes under the water. So if any sort of repair is necessary, this status quo order will disturb that also. Only that clarification lordship will give, let the injunction remain.
What should be repaired?
In case of minor repair, if necessary, they can do.
Of your house?
Minor.
Okay, okay.
That's all. I think it can be, so my learned friend also will not oppose. Let the injunction remain, my lord. My concession
Any
will not be
objection?
recorded.
You should-
Objection, lordship, with regard to that particular injunction petition, they have not mentioned anything about this flood affected area and some repairings are required.
No, now he is making oral
My
submission.
lord, I have got
Exactly.
photograph, video photograph.
If you are not opposing, we may dispose it.
Otherwise, why should we?
Because otherwise he is in possession.
Yes, admittedly, my
He wants to repair his residential house in event of flood.
my lord. And I'll show him a video for
The
photograph.
fact is that, lordship, this aspect of the matter has not been related in the objection petition. Because if any sort of activities are required for the flood affected areas, some repairing, all these things, it should have been mentioned in the objection petition. They have not mentioned anything in the objection petition.
Technical objection, my lord, I'll leave it to your lordship.
No, then you,
Because the new
No, I have
ground-
mentioned in the memo of appeal, man.
Exactly, lordship, I have seen it, because the new ground. that has
It's
been
a
taken
very
in the-
small thing, man. I'm not opposing the prayer for injunction. I'm playing for a small clarification only.
To what
I
extent
don't-
they will do all these things?
No,
It's a
lordship will
matter of
mention
dispute.
that I'll not make any major changes.
you take instruction.
I will obtain instruction.
You obtain
Because
instruction
I
today.
have already obtained the instruction and they have mentioned all these things. I have noted down everything because they have said that there is nothing, no such requirement is there in this particular premises. On the
If it is,
pretext-
I will, if necessary, I'll show the
file
video
objection- I
photograph.
will file objection with regard to that, lordship, because
That will
certain
not
points
delay
there.
the matter, nothing else, man. I was thinking that.
Otherwise matter can be disposed of today.
Exactly. Okay, next date may be fixed on, this is the first time I am appearing in this case after filing the Okalatnama. Any date may be picked in the next week.
I can reflect what you have submitted in.
Yes.
Heard Mr. D. Mojumdar, the learned senior counsel, assisted by Miss, what is her name? S. Nath, the learned counsel for the applicant, petitioner. Also heard Mr. S. D. Chaudhary. SP Chaudhary.
This will only delay and
No, I'm saying
consume
about the
court's
next
time.
week, Lordship.
I'm telling my learned friend that you take over phone instruction. It can be disposed. Very
Because-
small matter, my lord.
Because the instruction I have to obtain.
This lordship is
difficulty
there for some important cases. It's a very small matter. I am conceding the prayer for injunction.
Yes, no, I will reflect that so that on next day.
Yes, yes. Any day in the
We
next week.
should not bother.
Today is
with
Friday,
these
Lordship.
small,
Fix it on
small
Monday also.
issues, man. Let it
Lordship
be
may
taken
fix
up
it
on
on
Monday. Lordship did not reflect anything. Let it be fixed on Monday. So let him come with the instruction over phone.
SP Chaudhary. Learned Senior Counsel for the petitioner has submitted that though the petitioner has impugned the order dated 9/7/2025 passed in Miss J case number 46/2023.
Although my concession may not be recorded.
Okay. 2023. Then I should not reflect anything.
My lord, that's what I'm saying, my lord. Let him take instruction. Lordship will dispose of
No,
with a
on
small
what basis?
clarification.
On what basis are you
No,
taking
that
instruction?
necessity of
Exactly,
repairing,
Lordship.
Yes,
that can
that
be
can be reflected. Yes, because this will order come in the way of making any
46.
small repair.
2026. Passed in title suit number 28/2023, whereby both the parties hereto were directed to maintain status quo in respect of the suit land and property till disposal of the main suit. Learned Counsel for the Learned Senior Counsel for the appellant has submitted that the land is present, suit land is the present appellant is residing over the suit land in his residential house, which is a flood prone area, and there may be necessity of minor repairing in event of any damage caused due to flood, and in such circumstances
Flood and rain, Lordship may say. Flood and rain.
flood/rain,
Assam type house, man.
and in such circumstances due to the status quo order in respect of the suit land, there may be some difficulty, and as such he prays for he submits that this matter may be disposed of by giving concession to the present appellant to repair his Assam type house in the event any such repair is required necessary due to any destruction/damage caused to the said Assam type house due to floods/rains. Mr. S.P. Chaudhary, the learned counsel for the respondent, submits that some time may be granted to him so that he can take instruction from the opposite party and respond to the submissions made by learned senior counsel. The prayer is allowed. Let this matter be listed.
29th,
29th.
29th.
On 29th of July.
There are orders of this one court, a recent judgment of Honorable Justice Devashish Barua, my lord, that this status quo orders are very vague, should not be passed. I've got a copy of the judgment also. I'll just produce on the next day.
Yes.
Item 4. May please your also. My lord, this is an appeal, my lord. Against him, my lord, judgment dated 5/6/2026, my lord.
for modification of the judgment, my lord, regarding that, my lord, maintenance, my lord. My condition is that I have filed this application for divorce on the ground of desertion. Initially, I filed an application for restitution.
Heard Mr. S. Islam, the learned counsel for the appellant. This appeal, Mita, আগৰ কেছটো যে আছিল ডি মজুমদাৰ, there instead of petitioner mention appellants, wherever petitioner word is used, use the word appellant. Yes, heard Mr. S. Islam, learned counsel for the appellant. This appeal under Order 43, Rule 1 within bracket R of the Code of Civil Procedure has been preferred by the appellant, impugning the order dated 3/7/2026 passed by the Court of Learned Civil Judge Senior Division, Dorong, Mongolday, in Miss J case number 17/2025, arising out of title suit number 15/2025, whereby the application for grant of temporary injunction under Order 39, Rule 1 and 2, filed by the present appellant was rejected. This appeal is admitted. Let the records of Miss J case number 17/2025 as well as scanned copy of the records of title suit number 15/2025 be called for from the trial court registry to take steps for requisitioning the records. Let also the notice be issued to the respondents. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 31st of August.
There is a alia for
May issue notice.
because there's urgency because they are getting to the only your photograph have annex. They have only after rejection of this your lordship injunction petition, they have damaged, they have cut our trees of our houses and also
Why injunction was rejected?
injunction rejected that it is your lordship and it is the base
Human
119. 119 your lordship.
Second week of June. 14th August.
They are also threatened to demolish our houses within 24/7. If it's not restricted, they will demolish your lordship. Because I have annexed a photograph due to showing his muscle power. These properties are ancestral property.
The suit is pending.
Suit initially they have filed suit. That's their suit is dismissed. And that suit we have filed injunction petition, dismissed and trial. Your appellate court granted injunction in favor of us. Till disposal of their suit. Their suit was 47/2019.
Thereafter,
Their suit is dismissed for default. And there is injunction in favor of us by the appellate court and that court. But till disposal of the suit, when the suit is dismissed for default, when interim was granted injunction, they did not proceed the suit. And they started showing muscle power and demolished our houses.
who filed title suit number 15?
15 filed by us, 47/19 filed by the respondents.
No, that suit has
dismissed for default. And that suit, there is an injunction order in favor of us.
But that goes.
That goes, your lordship. After that, they have disturbing us, your lordship. They have already take possession some portion of agricultural land and they are now trying to dispose it for my residential land. They have on 14/4/7 they have cut down our
No,
trees.
why your prayer was rejected?
Your lordship. Prayer was rejected only because that put some misconcept that there is a sale deed in favor of them. They are the nephew, your lordship. The respondents, they're showing that there is a sale deed in favor of us by my father. And there is 1974 to 70, there is 5 sale deed. They have now reported and sold it, backdated. And they are claiming for 2019 after the death of their father. And their father was my brother-in-law.
The solemnized marriage with my sister and estate, my house, Your Lordship. And it is my ancestral property, Your Lordship. I have annexed the photograph also showing you for your Lordship convenience that they have cutted trees, page 134 onwards, Your Lordship, there. On after rejection also, next day they have demolished our houses. Some portion demolished houses, cutted trees, and threatened to vacate the land. Otherwise, they will demolish within 24/7. Today is last date they have taken. I have, in respect of Schedule 2 land, there is a two schedule, Schedule 1 and Schedule 2. I am injunction between only Schedule 2 residential land. It's admitted fact it is in our possession. And Schedule 1 land is our agricultural land. Some portion they have already occupied it, they have disposed of there. In respect of Schedule 2 land, there is urgency there. It is our residential land. I am not for the whole suit land here. My injunction petition only for your injunction only Schedule 2 land is residential land. They have disposed it will be for loss. They also admitted that it is in our possession. In our their title, I have also annexed their title should also have annexed this, Your Lordship. Their suit was for declaration, ejectment, means profit, permanent injunction. Their suit, it is dismissed. And that suit, I have also filed, instead of counterclaim, the appellant filed a missed case. Missed case was rejected, then appellant.
Your suit is for?
My suit, Your Lordship, for declaration, recovery of khas possession, cancellation of registered sale deeds.
Recovery of khas possession means you don't have possession.
Possession of agriculture. There is two schedules. I am admitted also there. Schedule 1 land is, Your Lordship, is for, Your Lordship, cultivation.
Show me where is the schedule.
Schedule, Your Lordship.
Appeal to some.
Yes, Your Lordship.
Where is your
96.
injunction application?
Injunction application, Your Lordship. Page 89, Your Lordship. Schedule is page 96. Total 11 acres of land. Schedule 2 land is residential plots.
How much land is?
3 acres, yes, covered page. Resident premises. Page 95 prayer, Your Lordship. Injunction restrain the opposite party that may one agent from disposing the petition for Schedule 2 land till disposal of the suit. They also admitted that Schedule 2, their suit also. Earlier, there is injunction in favor of page, Your Lordship, page 58, Your Lordship. There is injunction earlier, page in favor of us.
Tell you. Heard Mr. S. Islam, I. S. Islam, learned counsel for the applicant. This application under Order 39, Rule 1 and 2 of the Code of Civil Procedure 1908, read with Section 151 of the said code, has been filed in connection with first appeal against FAO number 50/2026, wherein the present applicant has impugned the order dated 3/7/2026 passed by the Court of London Civil Judge Senior Division, Darong, Mangoldai, in Miss J case number 17/2025, arising out of title suit number 15/2025, whereby the prayer for grant of temporary injunction in favor of the present applicant in respect of the suit land was rejected. The connected appeal has been admitted and notices have been issued to the respondent. Let notice be also issued to the opposite parties in this interlocutory application. The applicant shall take steps for issuance of notice upon the opposite parties by speed post as well as by usual mode within 7 days from the date of this order, returnable on 14th of August. Learned counsel for the petitioner submits that since the petitioner is apprehending forceful disposition from Schedule 2 land wherein he had his residential houses and he is in possession of the said plot of land, comma, by the present. Where is the threatening? Which statement? Which paragraph?
Your worship, page 9, para 7 of my IA.
ये लिख ले। Respondents who have threatened the applicant to vacate the Schedule 2 land within 24/7/2026. Otherwise, they have threatened to demolish his residential house. Learned counsel for the applicant has submitted that prior to filing of the title suit number 15/2025 by the present applicant, the respondent side had filed a suit in respect of the said plot of land, which was registered as title suit number 47/2 47
47/19.
47/2019, wherein the present applicant petitioner had prayed for grant of temporary injunction against the plaintiffs / present respondent for not disposing him from the suit premises, and said injunction was also granted. Granted by which court?
Civil Just, Your Worship. Civil Senior Division. Your
In appeal.
Appeal, yeah, page 58.
Was granted by the First Appellate Court in an appeal preferred by the
Here, page 23 years.
by the present petitioner, that is Miss Appeal number 13/2024. The learned counsel for the petitioner submits that, however, later on, the respondents who were the plaintiffs in title suit number 47/2019 defaulted in appearing before the trial court, and the injunction granted to the granted in favor of the present petitioner by the appellate court also got vacated. He submits that though the trial court has, by passing the impugned judgment order, refused to grant temporary injunction in favor of the present appellant. However, the said order has been put to challenge in the connected appeal, and the appellant, the petitioner, is hopeful of getting a favorable order in the connected appeal. However, in the meanwhile, if the respondents, if the opposite parties are not restrained from dispossessing the petitioner from Schedule 2 land wherein the present petitioner has his residential house, he shall be greatly prejudiced and would be suffering irreparable loss. Stop. Considering the submissions made by the learned counsel for the applicant, as well as considering the averment made in this interlocutory application, this court is of considered opinion that the possession of the present petitioner in respect of Schedule 2 land is required to be protected at least during the pendency of the connected first appeal. FAO number connected FAO number 50/2026. As such, till the next returnable date, the respondents are restrained from disturbing the possession of the present petitioner over Schedule 2 land. List accordingly.
No places.
F6. May I please have a minute? Regular statutory fasting.
Lord Mr. A.K. Hussain, learned counsel for the appellant. This appeal under Section 96 of the Code of Civil Procedure 1908 has been preferred by the appellants, impugning the judgment and award, judgment dated 30/5/2026, passed by the Court of Learned Civil Justice Senior Division, Chirang, in title suit P number 1/2022, whereby the suit preferred by the present appellant was dismissed. I have gone through the grounds stated in the memo of appeal. This appeal is admitted. Let the notice be issued to the respondents. The appellants shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 31st August. Let the records of title suit P number 1/2022 be called for from the concerned trial court registry to take steps for requisitioning the records. List accordingly.
We stay within 7 days. Fine. Highly appreciated.
May it please your lordship. My lord, the present appeal under section 23 of the Railway Claims Tribunal Act. Notice may be issued at this date.
And Mr. D. Rathi, learned counsel for the appellant. Also heard Miss
R. Dev Lordship.
R. Dev, learned counsel for the respondent, sole respondent.
Yes, my lord.
This appeal under section 23 of the Railway Claims Tribunal Act 1987 has been preferred by the appellant, impugning the judgment and order dated 27/5/2026, passed in the OA number within bracket Roman 3 / capital GHY /28/2024 by the Railway Claims Tribunal. Your claim was dismissed,
Yes, my lord.
whereby the claim filed by the present appellant was dismissed. Let the records of when the aforesaid original application be called for from the Railway Claims Tribunal, Gauhati, registry to take steps for requisitioning the aforesaid records. List this matter after receipt of the records on after 4 weeks.
My lord, it can be fixed for hearing if it may be, because TCR is.
Let the record come
My lord.
after 4 weeks on it.
Much obliged.
Please, your lordship, for preferring this appeal.
Heard Miss P. Fukon, the learned counsel for the appellant. This appeal under section 173 of the Motor Vehicles Act 1988 has been preferred by the National Insurance Company Limited, impugning the judgment and award dated 7/4/2026, passed by the Motor Accident Claims Tribunal, Dibrugarh, in MEC case number 33/2023, whereby the present appellant was directed to pay a compensation of rupees 18,23,400 along with an interest at the rate of 7.5% to the respondent / claimant. I have gone through the grounds stated in the memo of appeal. This appeal is admitted. Let the records of MEC case number 33/2023 be called for from the concerned tribunal. Let also notice be issued to the respondent. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 31st of October.
Item 49. Actually, I am for the sole respondent in this case.
Appellant,
Not present.
we will adjourn this. None has appeared for the appellant on call. Mr. A.J. Sakya, the learned counsel for the respondent, is present. Let this matter be listed after 4 weeks on a date to be fixed by registry. For reasons mentioned in the order, judgment, this appeal is allowed and the compensation granted to the claimants is modified to rupees 8,70,000.